Hello, good evening. You are live with Lawman and Carmen B. Courtside, a podcast that deals with criminal law in the state of California.
Hello, everyone.
We are here to answer any questions that you have about your criminal cases or about new laws that may impact you or your loved ones.
We don't represent anyone, and we're not representing that we represent anyone. We are giving mere advice based on general principles of the law.
And actually not advice, it's actually more of information. This is an informational channel to answer the burning questions that you may have about the laws in California that impact you or your loved ones.
Now, tonight specifically, I think we want to talk about something, and that is one of the new laws that have changed this year, effective this year. There have been several laws that have changed that tend to give you back your rights. And that's probably the best way to put it, because everyone knows your Fourth Amendment right is gone when you are on probation and have a search condition. So, one of the laws tonight we got to talk about is AB 1950. And you've probably heard about it, hopefully, but it is in effect now. And one of the good things is that it means that those who are currently on probation, if you have served your time on probation that the law allows you to serve and then get off of probation, you can do that right now.
And actually, what AB 1950 does is for most general offenses, it changes the probationary period. So if have been on probation in Sacramento County for a felony, you know that it is common that the court will put you on a 5-year grant of felony probation. And during that 5-year period, most oftentimes you're going to be subject to search and seizure by law enforcement during that 5 years, and they may use it to harass you. What AB 1950 does is reduces that probationary period to 2 years. Now, it applies to most general felonies. There are a few exceptions that it does not apply to, but most of your general felonies, if you're currently on probation, you can contact an attorney, you can go back to court, and you can get that probationary period reduced to the 2-year time period. So, for example, if you're on probation right now and you've been on probation for 2 years, and maybe you're now at the 2.5-year mark, you can now go back to court and get that probation terminated.
And now she said there's some exceptions. So there's some obvious exceptions. Whenever the crime itself dictates the length of time that you should be on probation, that would be an exception. If the crime itself says you got to serve 5 years, 4 years, 3 years probation, you got to do that. Domestic violence cases, any case involving domestic violence, is not supposed to be subject to that law. However, you can get the 5 years reduced to 3 or 4. Sex cases, things involving having to register under 290. Those, if there's a term of probation that is laid out and the law allows it, then they will remain. And it would be difficult removing that. Serious and violent felonies, obviously, it wouldn't apply to. You actually could do a robbery and get probation for it. If you did, then it wouldn't be under this statute. You would serve 5 years if that's what the court gave you. So there are some exceptions, which is why you have to examine with a lawyer or someone to go over and see which ones apply for you. And what if you're on multiple grants of probation, Carmen?
It applies to all of the grants of probation that you are on. So the grants, you could be, sometimes someone is on a grant of probation and they've been on that grant of probation for a year. They are convicted of yet another offense. They're placed on another grant of probation. Those 2 grants of probation run at the same time. So whatever time was remaining on the first grant runs at the same time that the second grant is being served. But both of those, as long as they are not a crime that is excluded from this particular law, the probationary period could be reduced to that 2-year period. In addition, As to misdemeanor crimes, it reduces the probationary period on most misdemeanors, again, not all, but on most misdemeanors to a 1 year time period. So if you were on probation, on a grant of probation, a 3 year grant of probation for, let's say, a possession of a firearm, and you've already served a year or close to that year, you can come back to court and now get that probation reduced to 1 year. Or if it's already been more than 1 year, you can come back to court and get that probation terminated.
And the key about terminating probation is not only getting off of the terms and conditions of probation, but also that you can now have the case expunged. Now, expunged is a bad word because it assumes that something is erased. It assumes that something is removed, but that's not true. It's not necessarily always removed because what expungement really means is that the court can go back and dismiss the case that you had as long as all the terms and conditions are done and that the term of probation is over. You can always go in for expungements when the term of probation is over. But like I said, the expungement order from the court doesn't say erase everything off of a rap sheet. It will merely add to a rap sheet that the case has been dismissed pursuant to Penal Code Section 1203.4. Now, the expungement law is quite large right now. You can do a lot of things, and it just depends on what has happened to you. Know that if in fact charges were brought and then dismissed or never filed, that's not called an expungement because you haven't been convicted of anything. So you would be going in under penal code sections to try to then remove an arrest or clear your record and from the terms of removing the detention and arrest. But that would depend, and that's just the battle, because what we got to think about is this: for every arrest, officers must have probable cause. Probable cause means a strong suspicion that, number one, you did a crime, and that, number two, a crime occurred. So, that probable cause standard is just enough to arrest, it's just enough to hold a person over to go to trial. Doesn't mean you're guilty, not at all, but it's enough to arrest. So, if in fact they never file, if they dismiss charges after they're filed, then you're in a situation where there may not have been probable cause to arrest. And that's where you would have to go in and show that there was not, and maybe get it then sealed not to show an arrest. But if arrested, if then you were fighting the case, and if it was resolved misdemeanor, felony in some way, then it will be a conviction on your record and people can see that. And that's where the expungement law jumps in to say that we can now amend your record to show it was dismissed. And for most purposes, you can say that you don't have a conviction. Now, there's one catch in 1203.4, Carmen. You want to tell them about how it doesn't cover everything?
I'll go ahead and let you cover that.
If, in fact, you want to get a license from the state, if you want to run for office and collecting campaign money, if you want to run a daycare center, if you want to apply to some agency where you've got to do some not undercover, but a high clearance or something like that. If you run for office, even that 1203.4 does not mean that people can't see it or deal with it. It just means that you may be required to disclose it, but they may not do anything with it. And there are employment laws now that have come out that talk about whether an employer should even see such a thing. And if they do, they have to give you an opportunity to be heard on it before removing you, because they can actually hire you. You can start working and then they can do a background check. And that whoever does the background check, we don't know where they go or what they get, but they may report back something and you know that you've expunged it, but that wasn't the question on the application. So they'll confront you and they'll say, hey, what about this stuff? And then you're supposed to get an opportunity to be heard on that first. before they can take action. But if they're private employers, and not state, county, or anything like that, then you really got to watch out. So 1203.4 is not everything. It doesn't just remove everything. That's why expunge is a bad word. It's more like it dismisses a case after you have served all your time on probation, done all the things necessary.
But dismissed, as Lawman was explaining, does not mean erased. It will still show that you were arrested, detained, or cited for it. It will show what the outcome was in terms of if you resolved it, or if you were convicted by trial, or if it was just outright dismissed, or if you were placed on probation and then you completed the probation successfully and you came back and made the 1203.4 motion. It will show that that motion was granted and it was dismissed on that particular date, but it does not erase it. And I think that's a error that a lot of people believe, is that if they get a conviction expunged, that it completely erases it from their record, and it does not do that. The only thing that erases an arrest or from your record is a finding of factual innocence, and you cannot get a finding of factual innocence on a case that you actually pled to or were convicted of, unless there's some, DNA evidence, and that's a whole different process where you're thereby exonerated. That's not the kind of thing that we're talking about here. I do see a couple of questions in the chat that are not directly related to the topic, but I would go ahead and read that and answer that for the chatter. I see the one question is, I was giving my friend a ride when the cops pulled us over. She is on probation, but I am not. The cops searched my car. Can they do that?
All right.
You
Good
want
question. Here's the thing. This is all about the Fourth Amendment right here. It's all about being free from seizures and searches. And the law states that officers must act reasonably. And that's a very strong word, but it is the law. Reasonable behavior we will protect. So, depending on why you are pulled over, would be the first issue. How come the cop is pulling you over? So let's just say, because here you didn't say, but had to be a vehicle code violation or some reason. And that's where, when you stop someone, Carmen, that way, what's the standard?
The standard is reasonable, articulable suspicion that they have committed or been involved in a crime.
Correct.
And so that allows them to detain you.
Right.
A detention is not an arrest, but they may detain you and have you waiting basically while they're furthering their investigation. Now, the problem that we run into a lot of times is you, as the citizen, have no idea what information the officer has. And a lot of people tend to immediately want to go into argument mode.
Talkie.
That is not the best thing to do. The better thing is to ask whether or not you are free to leave. If the officer says yes, then you leave and get out of that situation. If the officer says no, you assert your right to remain silent. You can provide your name and identifying information, but any questions about where you're going, where you've been, who were you with, you don't need to, and you should not answer those types of questions.
Correct. And that is following the law. In fact, there's a case in 1983, People versus Royer. And that case states that you don't ever have to talk to police officers, even if they come up to you. No matter how they come up to you, you do not have to talk to them. And it's okay. Even if you want to keep walking away, it's okay, because the officers have to establish that they are detaining you for a specific reason. You don't have to know, and you generally don't know. And that's the problem. That's why asking questions of the officers is never a good thing. The best thing is always ask, are you free to go? Under any, I don't care what they say to you. Are you free to go? Because if you are not free to go, you are detained under the Constitution, even though you're not cuffed, even though you haven't been directed to go somewhere or do anything. They don't have to touch you to detain you. Detention just means that They have stopped me from doing whatever I am going to do. And I have stopped doing that because of the direction of the officer. Sometimes the officer don't have to say a word. If 10 officers came up to you and surrounded you right on the street, you could say, let's see, am I being detained? You could ask that question, and it'd be a legitimate question to ask. In fact, you shouldn't ask that question. You should only say, am I free to keep on walking? Because if they don't say anything, you walk. If they say yes, you walk. If they say no, even though they've done nothing but surrounded you, you are now detained. And now your Fifth Amendment right kicks in. Now, here we had a police pulls over a vehicle. A passenger apparently is on probation, but not the driver. So, what do you think about how did the cop find out the passenger be on probation, Car?
There's any number of ways the officer might have found out. He might have recognized her from prior contacts. He might have, when you're stopped, law enforcement has a number of tools that people are kind of unaware of. Perhaps she had been stopped before driving that car. So even though she's not the registered owner, that car has been associated with her in a law enforcement database. And so when they see that car, they're going to think, oh, is that person who's on searchable probation in that vehicle? And it's very easy. We like to hope that law enforcement is not making up reasons to stop individuals, but we know that sometimes they do. And it's very easy to use a traffic violation to stop someone, to say, oh, you didn't use your turn signal, or you crossed over the limit line, or you were speeding. It's difficult to contest those kinds of allegations. But one of the good things that we do have now is that there is a lot of body cam and in-car camera footage that not only shows the interior of the car, but shows what's happening outside of the car in front of the officer's patrol car. So if an officer says that someone is speeding and you know that you weren't speeding, and we can get that camcorder, that recording that shows that, you know, the officer's speed of his vehicle and the time it took him to approach your vehicle does not indicate speeding at all.
And one of the best things about the cams is that they will record about a minute after they're turned on. So when the lights come on, the recorder actually records about a minute before that. So you catch what's going on right before the lights are turned on. But here, let's just say the cops pull them over.
I think it's less than a minute.
30 seconds?
Yeah, I think it's about 30
Okay.
seconds that it records before they actually activate it.
But know that it's on when the lights turn on.
I do see another question in the
chat. We should answer that one because now they pull over the car. Driver, I'm not on probation, car. So how do you think the cop knew? I mean, even because this person is not the person who committed the vehicle code violation. So why does the cop get to talk to her?
And the cop will say that it was consensual. He'll say, I approached the vehicle, I asked for both of their IDs or their names, and then I ran them, and that's how I determined that she was on probation.
But does she have to give up her name when she's not the driver?
When she is not the driver, she doesn't have to give up her name, because she is not the person that he's stopping for the violation.
So when the cop is saying that, hey, I'm not the driver. Did I do anything wrong? Should they say anything?
They don't need to say anything at all. But we also have to look at that it's one thing to describe how things should actually occur theoretically, and then it's another because we know how things tend to operate in the real world. A lot of times when people are stopped by law enforcement, they're nervous. They just want to cooperate and get this contact over with as soon as possible. So don't feel bad about giving the officer your name if you do give him your name. But know, again, that you don't have to have consensual contact with him if you are not the target of whatever he's investigating.
But wait, now I've seen the cop come up and they'll go, all right, everybody tell me your name, right? Now, what do you think the person should do? Because even though I may be on probation, the officer may not know that until they get my name and they run it. So we've been talking about the detention. Now, this person's not the one who's the subject matter of the detention. So does the cop get to say, I want to know who is in this car?
Technically they are detained even though they aren't the driver, because they're in a vehicle. Most people aren't going to get out of the car that they were in, going to whatever location they were going, and simply walk away because law enforcement stopped them.
But can't I do it under the law? Can't I say, as the passenger, am I free to leave?
You could ask that question, but
And if the officer says yes,
then you could leave.
I leave. Now, if the officer says no, now the passenger is detained, right?
That is correct.
And the officer better have, what did you say that was? Some kind of reasonable suspicion?
Articulable suspicion to
Right.
explain why he is detaining that person.
Right. Now, that's important for this reason, because it's at that point that the officer has now detained you. So now you have to give him a name. But only then do you have to give him the name. So when that name comes out then and they want to run it, they find out that person's on probation. So now, she said, they searched the car. Did they ask everybody can they ask everybody then to get out and search that car?
They can ask everybody to get out and search that car once they know that someone in that car is on searchable probation.
But wait a minute.
It's the nature of the car.
But wait a minute. Don't you need probable cause to search that car?
You don't need probable cause when the person is on probation.
But I'm not the driver.
I know, but you just changed it such that he told her she wasn't free to leave and he's detaining her. Now, that may result in an issue later on if there is something that is actually found and there are charges that are brought. But even in the instances where there are not, if you feel that an officer has illegally searched you or mistreated you in any way, you should be making those complaints with IA. And that is for that particular agency. And the reason for that is that it can help in the future when that same officer is involved in further misconduct. We are able to then, within a certain time period, look back at other allegations of misconduct by that officer. But if you don't make those complaints, we have no way of knowing about it, and that officer gets to get away with continuing that behavior.
But Carm, they call me lawman for a reason, because I'm going to stick with the law here. What if the passenger gives the name, cop runs it and says, you're on probation? What can they search then? Because what should they search me and I'm not on probation? Should they search my whole car?
They can search the area within the reach of that passenger, which is pretty much going to be the entire passenger compartment area of that car. So they're not going to be limited to just the seat that she was sitting in, because a car is small enough that you can reach behind you and put stuff in the back seat, on the floor, and that's,
center console.
Yes.
What is that? Glove box, side boxes.
Yes.
So the officer, so basically, if a person is on probation and they're riding in your car, an officer learns that, then they can search the interior. I think that was Arizona versus Gant, which is one of the largest U.S. Supreme Court search cases regarding automobiles. And that just means that they're restricted to what that person could reach. Now, if I have a trunk that is separated, a trunk that is locked, can they, because the passenger is on probation, search the trunk? What do you think, huh? Can they search the trunk?
With the passenger using the passenger's probationary, they shouldn't be able to search the trunk because it's not the passenger's car. But again, in real life, odds are they're going to search that entire car. And again, the issue is going to be if they find nothing, there's no criminal case, we never find out about it. So again, you have to make those complaints regarding that.
But now I'll tell you, but last thing on that though, because if in fact the officer wants to go to the trunk, understand that it is the driver who probably has control over a key or a fob to get into it, or the button is on the driver's side. So because Arizona versus Gant says they can only go what they touch, if the officer hasn't seen that passenger get into the trunk, then the officer should not search that trunk, and the driver should say, I don't consent consent to search at all.
That is correct. Once someone consents to the search, the officer has pretty much leeway. So sometimes what officers will do is talk to you about the inconvenience. Well, if you don't agree to allow us to search, we're going to have to bring the drug dogs out here and we're going to have to get a search warrant. It's going to take so much more time. And a lot of people, because they're concerned about the inconvenience and they think that it's going to be so much longer, they just think if they tell the officer, okay, it's fine, you can search, that either one, because they've consented, maybe he'll believe that they don't have anything and won't bother to search, or two, that it'll make the process be over sooner. Usually neither one of those is correct.
Right. And the thing is that, look, under all circumstances, once you have said, am I free to leave? And the officer gives you a yes or a no. If it's a yes, you're going. If it's a no, you have nothing to say except you want your lawyer. And you keep saying that. I want my lawyer. All you have to give up is a name and you want your lawyer. And that's it. Now,
and just so that we're clear on that, you don't have to have the name of your attorney. So you don't, it's not as if you have to, oh, I better have somebody already on retainer that I can state their name. No, just the general, I would like an attorney is enough. And that should cease all questioning. Now, a lot of times, again, in reality, it doesn't. The officer will continue trying to talk to you and to try and engage you in conversation to get you to say things to him. You have to not fall for that. When you demand your attorney, at that point, there should be no further conversation. You can repeat, I would like my attorney. I would like my attorney.
No,
and repeat that.
I want an attorney. You cannot be ambivalent at all. You can't, should I get my lawyer? Shouldn't I get one?
No.
I want my attorney before I say anything.
Yes.
Period.
And it doesn't have to be my attorney. It could be an attorney. I want an attorney.
Now,
and if the officer says, well, are you sure you want it? We could clear
I
this
want my
all
lawyer.
Up. Repeat that
I want
until
my lawyer.
He leaves you alone.
Say it in a different tone, in a different chord. I want my lawyer. I want my lawyer.
So we have another question here. My boyfriend is on probation. We do not live together. Can cops legally search my house if he visits me? Keith?
Well, remember we talked about probation. And if it's a searchable probation condition, then when you're on probation, you've given up your rights to be free from any searches, day or night, with or without a warrant. However, just like in the automobile situation, you can only search where the probationer has been. A visit to someone else's home does not mean the officers can search wherever they want to search. In fact, they would have to establish when they're in the first they got to get in the home. So I don't know why anybody opens the door and has a cop come in. But once you have done that, you've made mistakes. But once you've done that and they find out somebody's on probation, they can only search where that person has been. That's why shut up.
I would state this. Mr. Staten said, he doesn't know why someone would open the door. I've seen cases where there's someone who's outside of the home. They may have a key to the home. Maybe they borrowed their girlfriend's car, and so the house key is on that key ring, but they don't reside there. I've seen officers take that key ring, go to the door, use it, unlock the door, and step in the home with the individuals, the residents of the home, not even realizing that officers were coming in. So it's not always necessarily a situation where the citizen is opening the door. In that instance, the officers are wrong. They should not be searching your home, your entire home, just because your boyfriend, who is on probation, has visited there. In order to search your home, they would need to get a warrant or they would need your consent. So you repeat, you do not consent to them searching your home. You don't consent to them entering your home.
Without
and
a
you
warrant.
can do this in a way that is respectful without engaging in a huge argument with the officer. A lot of times the officer is going to overstep his bounds and he's going to do whatever it is that he's going to do. If he's going to search, even if it's an illegal search, he's going to do that search. But if you state you don't consent and that they need a warrant to search, at least that will be captured on the officer's body cam, and that will give us something to work with if you are actually charged with a crime as a result of that search. Again, if you're not charged with a crime as a result of that search, but you still feel that the officer violated your rights, we need you to make those complaints. And that's how we weed out these officers who are overstepping their bounds and who are acting outside of the law.
There's a tool that people have been using lately, and that tool is a cell phone to record the situation. You can record officers' conduct as long as you don't get in their way of doing so. Now, the house thing, though, look, don't ever let a cop in unless they have a warrant, unless you're on probation. See, so that probation takes that away. So, however, the cops get in, realize the answer to that is they can only search where that person would have been. Even if that person lives there and rents a room out, they can't search everywhere, but know this, they can search the common areas, the kitchen, the bathroom, and the hallways, storage areas,
That's
garage.
only where the person actually
Lives
lives
there.
at that residence. If they
Right,
don't live at that residence and they are merely a visitor, the officers do not get to come in and just do a
right,
full search of your home. And there's no way for them to know specifically where that person was in your home unless they're conducting surveillance and somehow
right.
looking in the windows. So even if they indicate, well, we can search the area right where he was sitting, where there's nowhere way for them to know the area where the probationer was sitting. Tell them to get a warrant.
That's right. Oh, IA. I think somebody doesn't know what that means. Maybe. What do you mean by when you're
It's the
saying IA?
investigative agency for it's the investigative unit for the law enforcement agency that will investigate claims of the officer's misconduct.
Now, it's usually called Internal Affairs. Also, IA. One place though, SAC PD has an office of a police accountability, where there's a young lady who's in charge of reviewing complaints made against Sacramento Police Department. Sheriffs does not have that system. Sheriffs don't have any oversight. So you would complain by going on their website, probably getting a complaint form and sending it in, but it might go into oblivion and you may not ever understand or find out what has happened to that complaint. What's key is that when you make that complaint, that you follow up a little bit, that you make sure to keep that complaint. And hopefully, what you could possibly do is turn it into like the NAACP or the Urban League or some other community based organization that might keep track of things like that. I think that it behooves our neighborhoods to use churches and other community outlets to give a copy of that complaint too, so that that church and that outlet now can collect information on officers work in that area affecting their parishioners and their people, and it'll be information that would be kept and held in case there are complaints that need to go out against specific officers. Because let's say over a 6 month period of time, Officer Friendly is being complained about almost every other day, and a complaint is being filed against them. We, as the public out here, may never know that that's going on, but that organization that's holding all these complaints can now go down to the Office of Police Accountability. They can go right to the IA and they can say, we've got a lot of complaints about this officer and we want to know what would you do about it? Because now the citizenry is taking control. Realize we pay for these individuals to protect us and to serve us. And so they are also under the scrutiny of the mayor and city council and things like that. So if somebody is a bad apple, as they always like to say, there's one of them, well, get rid of that apple and do everything you can to bring it to light that the apple is rotten.
I would also just like to remind you, we have people that are in the chat, but you are also welcome to call in via cell phone. The phone number for courtside is 916-384-8204. Again, that number 916 384-8204. So you can call in with your questions live as well as putting them in the chat.
I see there was a question about being pulled over, and the cop said the rosary beads hanging off the mirror blocked your window. And then they search the car and take weed. Now, first of all, there's cases that say that the sight of weed inside your car, whether it's a joint, whether it's a small container, that does not give the officers probable cause to search the rest of the car. So, because weed is legal now. Okay. So that's one thing. Now, using the rosary to pull you over, well, if the officer says that and you're even talking about it, you've said too much. And that's why the thing is, the word is, am I free to leave? And the officer say, no, I'm pulling you over because of the rosary. And then you say, okay, then I want my lawyer. You give them the ID, and the officer should write a ticket then. But if the officer wants to search your car because of the rosary or because of the weed, they can't do it. So all you have to maintain is, I do not consent to search, and I want my lawyer. And that's all you say for the rest of the evening. Then, if they arrest you for anything they find, you still shut up. And what you want to do is talk to your lawyer that you get and explain to your lawyer what has occurred. And if you behave the way we're talking, they have not articulated anything as to why they're searching the vehicle, because they've got to have something, and weed doesn't do it anymore. Being in a high crime area doesn't do it anymore. There are cases out right now about being in a high crime area or somebody seeing people in a vehicle acting shady or something. And what happens is the officers go and they investigate, and people get arrested. But those are things that the courts are dealing with now. So it really behooves you and your behavior to not consent, to respectfully say, am I free to leave? And if they say no, I want a lawyer, and you have to let it go.
One other thing that we would like to remind people is that if you are arrested after you have followed this and you've said you want an attorney and you haven't made any statements, that when they take you down to jail and they put you in the booking cell where you can make free calls to your friends and family, do not talk about why you are arrested, what the officers found, what the officers said to you. All of those calls are recorded. Now, the recording may say this call may be recorded, but we know that all of the calls are recorded. And so anything that you say could be used against you in your case. So if you call your brother and you say, oh my goodness, brother, they found what was in the trunk, that is something that could be used against you to establish that you had knowledge of what was in the trunk. So if you're going to use the phone to call your friends and family members, it should be just to call and let them know where you are, that you're safe, and to start getting the bail money together.
I think we're going to have to sign off because of power wise, but but it's been a great time talking with you. I hope we answered some questions, and know that this is what we're trying to do, is just talk about issues that come up.
We want to keep the community and we want to keep the public informed
And
of
safe.
your rights.
And safe.
And the only way that you can properly exercise your rights is if you know your rights.
Exactly.
And if you know how the laws can be used to help you.
Correct. All right, Carm.
All right, lawman.
I think we're going to get out of you on this.
All right. We will be here every Friday at 6 p.m. Again, you can ask questions in the chat. You can call the phone number, or you can email us at courtsidepodcast@comcast.net. And you can email your questions during the week. And when we're doing the live session, we will answer those questions as well.
All right.
Thank you so much.
Take care, everyone.
Stay safe.
Oops.